Welcome to the deep dive. Today we're digging into something really fundamental in tort law. What happens when you know you've been injured and you suspect a company's failure caused it, but you just don't have that concrete proof, that eyewitness? How do you prove negligence when the specific screw-up happened behind closed doors, so to speak?
That's exactly the challenge, isn't it? It's about bridging that gap in evidence. And today we're going to explore how, sometimes, the circumstances themselves shout negligence so loudly that the law steps in. We're talking about res ipsa loquitur RIL, the thing speaks for itself. We'll use a really illustrative case, Cosgrove v. Commonwealth Edison Co. from Illinois. It's perfect because RIL worked against one defendant, the gas company, but failed against the electric company.
Okay, great. Sounds like a good test case. But before we jump into RIL itself, let's set the stage. We need to understand the basic duty involved. In Cosgrove, the plaintiff sued both ComEd, the electricity provider, and Negus, the gas provider, after a fire started near sparking electrical lines. So thinking about Negus first, companies handling dangerous stuff like natural gas, what's their fundamental duty to the public?
Well, the courts are very clear on this. When you're dealing with something inherently dangerous like gas, the standard of care is high, extremely high. The rule, drawing from cases like Metz, is that the company has to exercise a degree of care proportionate to the danger. That means taking, really, every reasonable precaution possible to prevent harm.
Okay, a very high bar. Now, Negus tried to argue, didn't they, that they only had a duty if they were actually told about a leak first. Like, if no one called them, they weren't responsible.
Yeah.
How did the court deal with that argument in the basic negligence claim count two?
Right, that was their defense. We didn't know. But the court shut that down pretty quickly. They basically said, look, if we let gas companies off the hook unless someone reports a problem, they'd have no reason to ever inspect or maintain their own lines. So no, Negus has an independent, positive duty to inspect and maintain its equipment. Ignorance isn't an excuse. They can't just wait for a call.
Okay, so that proactive duty exists regardless of notice.
Exactly. And the fact that witnesses saw that big blue flame coming from the ground, and then hours later a leak was confirmed in the Negus line, well, that raises a serious question about whether Negus breached that duty. So the court said the regular negligence claim against Negus could go forward. Summary judgment was reversed on that count.
Got it. So the baseline duty is established. But the plaintiff still didn't see Negus fail to maintain that specific pipe. That's where this RAL doctrine comes in, right, as a kind of inference.
Yeah.
Can you lay out the black letter rule for res ipsa loquitur? What does a plaintiff absolutely need to show?
Yes, RIL allows an inference or sometimes a presumption of negligence based purely on circumstantial evidence, but you need to prove two key things.
Okay, what are the two elements?
First, the event, the accident, has to be the kind of thing that ordinarily wouldn't happen unless someone was negligent. And second, the defendant must have had exclusive control over whatever instrumentality caused the injury, and there's a crucial limiter. REL doesn't apply if the accident could just as easily be blamed on, say, pure chance or an act of God as it could on the defendant's carelessness.
That pure accident escape hatch seems really important.
Like, wait.
Okay, let's test this. We'll use our structured approach. First up, the RIL claim against ComEd, the electric company, in count 3, which failed. Let's analyze Cosgrove v. ComEd. First, what are the legally dispositive facts regarding ComEd?
All right, for ComEd, the key facts were witnesses saw their power lines sparking. One witness saw a wire actually fall down during a significant storm. That fallen wire then ignited a nearby tree. And importantly, the fire captain testified about the bad weather, strong storms, rain, and mentioned that things like wind, lightning, even animals could potentially bring down a power line.
Okay, fallen wire during a storm.
Yeah.
And what was the core legal issue for applying RIL to ComEd?
The central question was whether that fire caused by the fallen power line during that storm qualified as an event that ordinarily happens only because of negligence. Did it meet that first RIL requirement?
Makes sense. What rule of law did the court apply? Please state the full rule and its elements again.
Sure. They applied the two-element res ipsa loquitur rule, element 1. The occurrence wouldn't ordinarily happen without negligence, element 2. The defendant had exclusive control of the instrumentality.
Perfect. Now for the court's elemental analysis. Let's walk through it element by element. How did the court apply that first element? The occurrence is one that would not ordinarily occur in the absence of negligence to the ComEd situation.
They really focused on the context of the storm. They reasoned that power lines, unlike, say, buried gas pipes, are exposed. They're out in the open, subject to weather, falling trees, animals, you name it. So because of that exposure, a downline isn't automatically a sign of negligence. Strong winds, lightning strikes, these are non-negligent reasons a line might fall. The court basically said negligence is not ordinarily the sole reason for this kind of event.
I see. So the storm, the environmental factors created ambiguity. It could have been an accident just as much as negligence.
Exactly. It fell into that category of things that can happen without anyone being at fault. The pure accident possibility was very real because of the weather.
Understood. So because that first element failed, it wasn't necessarily due to negligence. Did the court even need to look at the second element, the exclusive control part?
No, they didn't. Once that first element isn't met, RIL collapses. If the event itself doesn't strongly point to negligence because other causes are just as likely, it doesn't matter if the defendant controlled the thing. The inference isn't justified.
Right. Makes sense. So after analyzing the elements, what was the court's final conclusion regarding ComEd in count 3?
The court upheld the summary judgment for ComEd. They concluded that a fire caused by a power line falling during a storm just isn't the type of event that screams negligence. RIL couldn't be used against them.
Okay, ComEd fails the RIL test because of the storm ambiguity. Now, let's pivot immediately to the RIL claim against Negus, the gas company, in count 4. This is where it gets interesting because RIL succeeded here. Let's analyze Cosgrove v. Negus. What were the crucial facts regarding Negus's involvement?
For Negus, the critical facts were different. Witnesses saw a tall blue flame shooting straight up from the ground level during the fire, not from a wire, but from the ground. And significantly, several hours after the fire was out, the fire department detected a natural gas leak in the Negus pipeline right there, buried underground. They had to call a Negus crew out.
A blue flame from the ground and a confirmed leak later. Okay. What was the core legal issue in applying RIL against Negus?
It was really two things. First, does a fire being fed by gas escaping from a ruptured buried pipeline meet that ordinarily negligent test? And second, this is the tricky part, did the spark from ComEd's line, which actually ignited the gas, break Negus's exclusive control over its pipeline, the instrumentality that failed?
Right, that ignition source issue is key.
Right.
What rule of law did the court apply here?
Same rule, the two-element res ipsa loquitur test.
Okay, let's do the elemental analysis for Negus, starting with the first element. The occurrence is one that would not ordinarily occur in the absence of negligence. Why did a leaking gas line meet this test when the falling power line didn't?
The difference was protection and exposure. The court reasoned that a gas main bursting underground and feeding a fire does not ordinarily occur without negligence. Why? Because unlike exposed power lines, gas mains are buried. They're shielded from weather, animals, most external forces. So the court felt the probability was much higher that a break in a buried pipe comes from an internal problem like a defect in the pipe or improper installation or lack of maintenance, things within Negus's control.
Ah, so the buried nature implies internal failure, which points more strongly towards negligence.
Precisely. The court felt an inference of fault was justified when something designed to be protected underground fails like that.
Okay, that covers the first element. Now, for the second element, defendant had exclusive control of the instrumentality, and this is where Negus pushed back because of ComEd's spark right. How did the court handle that?
Yeah, Negus argued, hey, we don't control the spark, that was ComEd. But the court rejected that. They focused on the instrumentality that actually failed and created the danger, which was the Negus pipeline leaking gas. Negus didn't dispute they controlled their own pipeline. The court essentially said, if the escaping gas from your controlled pipe is a proximate cause of the injury, the immediate source of ignition is irrelevant to the control element.
So the spark was just a condition, not the core failure.
Exactly. The spark was merely a condition that acted upon the dangerous situation already created by Negus's failure to keep the gas safely contained in its pipe. The negligence, inferred by RIL, relates to the pipe failure itself. The court drew an analogy. Imagine the plaintiff was standing near the leak and lit a cigarette. The cigarette provides the spark, but it doesn't negate Negus's duty regarding the leaking pipe they control. The pipe failure is the key.
Okay, that's a crucial distinction. Control attaches to the thing that shouldn't have failed. So the second element was met too.
Yes. Negus controlled the pipeline. The pipeline failed in a way suggesting negligence, element 1, and the external spark didn't break that chain of control over the instrumentality causing the underlying hazard.
All right. So after analyzing both elements for Negus, what was the court's final conclusion regarding count 4?
The court concluded the trial court got it wrong. RIL was properly pleaded against Negus. A ruptured underground gas line does suggest negligence in a way a storm-down power line doesn't. And that intervening spark was just an igniting condition. It didn't defeat Nigus's exclusive control over the essential failed instrumentality, the pipe. So the RIL claim against Nigus should proceed.
Fascinating comparison. Let's try to make that first element ordinarily wouldn't happen without negligence. Really stick with a couple of quick visceral hypotheticals. Imagine you're just walking down a city street on a calm, clear day. Suddenly, a large sheet of glass falls from the 50th floor of an office building and hits you. Does RIL likely apply against the building owner?
Oh, absolutely. Yes. Glass doesn't just, fall out of skyscrapers on calm days. That points very strongly to some kind of failure, bad installation, lack of maintenance, maybe a window washer's error, all things typically within the building owners or their agent's control. The event itself screams negligence. That's a classic RIL scenario.
Okay, clear day, falling glass, RIL. Now, different scenario.
Yeah.
You're walking down the street, but this time there's a massive tornado ripping through, town sirens blaring, debris flying everywhere. The tornado rips a heavy traffic sign right out of the ground, and it hits you. Does RIL apply against the city for, say, potentially poor installation of the sign?
Almost certain, that's much more like the ComEd situation. You've got a massive external non-negligent force in a tornado, an act of God. The injury is just as easily, probably more easily attributable to the tornado itself than to any negligence in how the sign was installed years ago. The tornado makes the cause totally ambiguous. RIL fails on element one.
Right, the external force overrides the inference. Okay, that really clarifies the difference. This Cosgrove case is incredibly helpful for seeing that distinction in practice. So let's synthesize this. For someone listening, maybe facing a similar problem or studying for an exam, what's the actionable step-by-step checklist they should run through based on what we learned from Cosgrove?
Okay, based on Cosgrove, here's a practical three-step diagnostic for spotting and analyzing potential RIL issues. Step 1, high-duty check. First, ask, does this case involve something inherently dangerous? High-voltage electricity, natural gas, maybe elevators, explosives? If yes, remember the defendant owes a very high degree of care. This strengthens both a regular negligence claim and makes the RIL analysis, especially element 1, potentially easier to meet because failures are less expected. Think Nigus. Step 2, RIL element 1, the occurrence test. Now zero in on the instrumentality and its environment. Ask, could this injury realistically be attributed to pure accident or some external force unrelated to the defendant's care? Think storms, earthquakes, unforeseeable third-party acts, animal interference. If the instrumentality is exposed to these forces, like the ComEd power line, RIL probably fails right here. But if the instrumentality is normally protected, hidden, or internal, like the buried Negus pipe or the inner workings of a machine, and it fails, then element 1 is likely met. The failure itself suggests negligence. Step 3, RIL element 2. The control and condition test. Okay, if element 1 is met, the occurrence suggests negligence, then look at exclusive control. Here's the Cosgrove nuance. If some outside force provided only the final spark or condition that triggered the harm, like the ComEd spark igniting the gas leak or the cigarette igniting the gas, does that break control? Generally, no. You have to focus. Did the defendant maintain exclusive control over the essential thing that failed and created the underlying danger, the leaky pipe, the faulty brakes, the collapsing scaffolding? If yes, then the immediate trigger or condition usually doesn't negate their control for RIL purposes.
That's a fantastic framework. High-duty check, then occurrence test focusing on ambiguity versus internal failure, and finally the control test, remembering that the spark usually doesn't break control over the underlying defect. It really highlights how the difference between ComEd and Nigus came down to that subtle distinction. Was it potentially just an accident due to exposure, or was it a failure of something that should have been protected?
Absolutely. RIL is fundamentally about dealing with that information imbalance. The defendant controls the instrumentality. They know its history, its maintenance schedule. The plaintiff usually doesn't. RIL essentially says, okay, defendant, this thing you controlled failed in a way that looks negligent. The burden is now on you to come forward and explain why it wasn't your fault. It shifts the burden of explanation. So the final thought for you is this. Whenever you encounter an accident that just seems bizarre, something that makes you think, how could that possibly happen without someone messing up? That's your cue. Ask, is this truly an unforeseeable accident, or is this a situation where the thing speaks for itself, demanding an explanation from the party in control? That question cuts right to the heart of res ipsa loquitur.